psychopath. When you're lost, take your trust. That's me. That's so sick. I'm a fraud, call me a liar. A true psycho. Ooh, I'm a fraud, call me a liar. A true psychopath, don't love me. When you're lost, take your trust. Yeah, that's me. Oh, that's me, that's me, that's me. Yes, I'm a fraud. Call me a liar. A true psychopath.
Hello, everybody. How are you? Happy Tuesday. Okay, let me say hi to everybody really quick, and then we can get started. Hey, Music City Mom. Hey, Emily. Hey, Melissa Strange. Hey, Sexy Wild Thing Carol freaking Claus. Hey, Holly. Let's see. Hey, Cutie Pie. Hey, Callie, Mrs. M, Holden. Good to see everybody. Hippie Chick. I think I said hi to Emily, but in case I didn't, hi, Emily. Hey, Cool Gamer. Hey, Sam. How are you guys? Hey, Cement Shoes. Hey, Cutie Pie. Good to see everybody. I think I said Hippie Chick. I hope I did. All right. If I didn't, hi, everyone. Hey, Nadine. Thank you, babe. You're so good to help me watch with the chat. You're the best. All right. So tonight we're going to read a 3-page letter from Henry Dinkins. And while I'm talking to you, let's hope I can do this. Usually you guys know how it is. It's very difficult for me to talk and type at the same time, but I'm going to try it because I need to master this. Sometimes you have to do stuff on the fly and you should be able to type and talk at the same time. I did it. I typed the whole thing out. So I took screenshots of the letters and then I uploaded them to my drive so that you guys could see them so I could share them with you guys. So I will say this. I'm not going to lie. I have not completely read through them all the way because you guys know how I do. I like to be fresh and just give you guys my honest, immediate reaction. But I will say this. Henry Dinkins actually has nice handwriting, and I was shocked by that. I was like, oh, I can actually read his penmanship. Oh, did you, Holden? Oh my gosh. It's been a long time since I did me and Dr. B did Dahlia de Polita. Wow, she was something else. What's going on, please? Mike. She's a mess, that one. So apparently, and evidently, I don't listen, Google Drive. I know how to work Google Drive. I don't need your tips and tricks. Thank you so much. Sheesh, so rude. Anyway, now I forgot what I was going to say because I was yelling at the Googles. I forgot what I was saying. Anyway, so like I said, I have not read through them. I did glance over them, and like I said, he's got good penmanship. I noticed that he cited case law, And I probably will go back and look at that case law to, I don't know really what good it would do me. I am not an attorney. And so I can give my best guess. But you guys know, like, even though I've watched like 11 billion trials and I do the Googling and I try to learn as much as I can. Listen, I am not fixing to you bring all these cookies into no damn ass courtroom and try to represent myself or anybody else. Hey, Mrs. M, how are you? Good to see you. I don't even remember what I said to the in those roasts, Holden. Sometimes I just do whatever, and then it just goes. I say whatever is in my brains in the minute. Hi, MK, good to see you. And then when it's over, it's over. It's like out of my brain. The roasts are like the case is not, but the roasts are. So, Mrs. M, just a little brief synopsis. This happened in Iowa, and it happened back on July 10th of 2020. Little 10-year-old Briasia went to stay the night with her brother at her brother's biological father's apartment. Henry Dinkins is the biological father of Briasia's younger brother. And it was not Henry's house, which is kind of weird because it was, but it wasn't. It was the apartment was leased to his girlfriend, Andrea, but but she was there. And the next morning, Briasia was missing. The girlfriend says that she woke up probably about 2 o'clock in the morning, 2 or 3 o'clock in the morning, and she noticed that Henry Dinkins and Briasia were both gone. She went to the living room. She called him a couple of times. His phone went straight to voicemail. She looked around the apartment, couldn't find her. Went into the living room, kind of not knowing what to do next, and she hears Henry coming up the stairs, and he goes past her, goes into their bedroom, gets into the closet, gets something out of the closet or puts something in the closet. We don't know really. He could have done either one. Anyway, and then leaves again. And she goes to the bedroom to look out the window, and she sees Briasia downstairs in the parking lot next to the Impala, to her Impala, and by the passenger side. And Henry gets in the vehicle, and she cannot see whether Briasia is in the vehicle or not because the windows were so tinted. But she was, she was on the outside of the vehicle, and then the vehicle leaves, and there's no Briasia. So they end up finding her almost a year later, and she's just skeletal remains. But they charged Henry Dinkins with her murder. It's an awful trial. It's a bench warrant, it's a bench trial. So the judge is the one that heard the case. And on Friday, he is going to deliver his verdict. And evidently, Henry Dinkins wrote the judge ahead of the verdict, and has some things that he wants the judge to know. And speaking of the girlfriend, I am doing a little bit of, no, babe, no, you didn't take up my time. I just want to, no, I want to explain it because there's people come in on the live, but they also come in on the replay. And this is a good rundown. So this is not extra work. Don't you dare say sorry. Don't you dare to say that you're sorry at all. Sorry, I was reading Callie's question. I think, Callie, so anytime you plead not guilty and you opt for a trial, you have the option of having a jury trial or a bench trial. I personally believe that it was decided by his lawyers that this case is a circumstantial case, but it's also got some there's a lot of emotion to it because it's a 10-year-old child. Her youngest brother, who was 8 at the time of her murder, he is now 11. He was called to testify. And I think that the legal team really decided that that a judge of having a bench trial would be much more fair to their client, because judges, this is what they do. This is what they do for a living. They are human beings, obviously, but they're very usually are very good at removing their own personal emotions and feelings and judging the case based on its merits. They usually reserve their to expressing their feelings or any type of emotions at to the until the end. So when a jury trial and they're the jury comes back guilty, and then they do the sentencing and stuff, that's usually when the judges will speak about their feelings. But I really think that that is why they decided to do it. I think that this is I do it too, babe. This was not this was not a case that a lot of people followed. There is another case that I'm currently watching right now that I'm going to start covering. I just want to get through the Dinkins verdict, and I will start covering the next case. It is the case of AJ Friend. It's in Chicago. This happened in 2018 18. In 2018, his parents have already been convicted and sentenced, but this trial is the CPS workers. And I thought that it is an interesting trial, but I want to be able to give you guys like the backstory of his case and how we're here now with the CPS workers before we just jumped into the trial. And I'm working on a video for the members for you. So yeah. And then Cray Cray, I was strolling through these YouTube streets, and I came across a video, and I need to check the validity. Oh, Punksy, thank you so much. That's so sweet of you. I appreciate that. Thank you very much. I was, and I came across a video that has Andrea's back, like it's not really a back, it's kind of a background check. It's more charges, but it appears, and I want to say that it appears, I will have to vet this for myself, but it appears that Andrea caught some federal charges related to this not specifically to this situation, but because they searched her home and they found a firearm. Okay. Apparently she had applied for a firearm, and when she applied for it, she put down that she did not smoke marijuana. And apparently in Iowa, you cannot have a firearm if you are a marijuana user. And so they charged her with that. So, but potentially, but it's interesting because her charge is July 10th of 2020. So I want to vet that a little bit more. And I also want to talk tomorrow night. We're going to talk about that. And we're going to talk about more of Dinkins and his past. But excuse me, I want to make sure that I have that information accurately. And I kind of planned to do it tonight, but then boom, this letter. So without further ado, let's read this letter. All right. All right. Let me zoom in on it because, all right. I zoomed too much. Hold on. Let me scroll up. Really? Hold on. I'll just move it over here. All right. Judge Latham, I'm writing you with urgency, attention that the state has used deception and sabotaged this whole case to fit their opinion of a theory, which I have proof if giving the opportunity to show you their lack of honesty to the courts and the public. First and foremost, the state did not obligate the court's order when my attorney filed for request for production and disclosed by counsel, and pursuant to Iowa Rule of Criminal Procedures 2.4 2.4142, stating the following item of evidence, if in possession and control of the state of Iowa, are necessary for preparation, the defendant to inspect copies or photographs or exhibits or any evidence the state intends to offer in evidence at the trial or were obtained from or belong to the defendant. Okay, you're going to need to be more specific about that. Rule 1.517, consequences of failure to make disclosure or discovery, which I find it interesting that he's writing this and not his attorney, but let's keep going. Rule 1.5171, failure to disclose or supplement if a party failed to provide information or identify a witness as required by Rule 1.5004 or 1.5083, the party is not allowed to use that information or witness to supply evidence on a motion at a hearing or at trial unless the failure was substantially justified or harmless. The failure to act described in Rule 1.5174 may not be excused on the grounds that the discovery sought is objectionable. Disclosure of expert testimony, A, in general, in addition to the disclosure required. All right, hang on a second. Let me get to the other one really quick. Let me get over here to share. Let me hide this so you guys can see. Hey, Allie, good to see you, babe. All right. StreamYard is really lagging. Come on, StreamYard. All right, let me add it to the stream really quick. By Rule 1.5001, a party must disclose to the other parties the identity of any witness the party may use at trial to present evidence under Rule of Evidence 5.702, 5.703, and 5.705. 3. Any exhibits that will be used to summarize or support the opinion. Rule 1.500, duty to disclose, required disclosure 1.5001. A, in general, except as exempted by Rule 1.5001E or otherwise stipulated or ordered by the courts, a party must, without awaiting a discovery request, provide the other parties to all document electronically stored information, intangible things that the disclosing party has in its possession, custody, or control, any may use to support its claim or defense unless the use would be solely for impeachment. I would have to say, Judge Latham, that the state didn't provide at least 50% of those exhibits until the day of trial, and there are still others the state haven't provided to us, the defendant. If giving the opportunity to prove this on the records, I can show the deception and how they sabotage a lot in this case, I showed you already where the state moved exhibits to fit their story in trial. I have plenty more to show, and the public those exhibits was also giving to us during trial, not before. I'm going to have to look this up. I think I understand what he's trying to say, but I'm not 100% sure that this is that he is interpreting the law accurately. And like I said, I find it, oh cripes, I didn't mean to do this. Um, I'm shocked that he is filing this and or making the court aware and not his attorney. This is something that an attorney could file. I find this interesting. So give me 1 second more and I will share the screen again for the third page. All right. Come on, StreamYard. All right. Let me just make sure. Let's see. Rule 1.1012, grounds for vacating or modifying judgment 1.10125, unavoidable casualty or misfortune preventing the parties from prosecuting or defending 1.10126, material evidence newly discovered which could not with reasonable diligence have been discovered and produced at trial. Okay. But you have to, you can't just say that you have to say what it is. You can't just cite the case, the law, the procedure. You have to say what you're talking about. Judge Latham, I was also looking under official comment enactment 1943 federal practice. We come now to the question of enforcement without adequate sanction. The procedure for discovery would be ineffectual under Rule 37. Any party who seeks to evade or thwart a full and candid discovery incurs the risk of serious consequences, which may involve imprisonment for contempt of courts for disobedience of court order. The entry of an order that designated facts be taken to establish the entry of any refusing the disobedience party the right to support or oppose designated claims of defense, strike out pleadings by default dismissal. Like, I don't know what he's talking. I mean, I know what a Rule 37 is, but I don't know what he's talking about here. So that's his letters. Apparently he's saying that they didn't get it's what he did was cite case law. Hold on a minute, because that feels like it's incomplete, but I know for a fact that I screenshot each and every page. But let me just double check because I don't want to give you guys like half the story. But you can listen. Wait, I understand what he's trying to do, but the deal is this: you have to you cite the procedure that was violated, right? But you also have to cite how they violated it. You have to give examples. You can't just be like saying, okay, they violated it. Hold on. Let me see if I can find. Oh, apparently it's Friday the 15th. I was wrong, not the 14th. All right, hold on. Let me find where I clicked before. Because oh, my own thumbnail came up in the search. How funny. Where is this damn ass letter? Hold on, let me see. That's page 2. All right, there is. Hold on a minute. What the frack? That's page 3. There was a 4th page and I missed it. All right, hold on. Here's the 4th page. I'm not going to download it, but hold on. Oh, this is not the this is a different letter. He's written the judge before apparently about his previous attorney not giving him the not being on top of his case. Let me see what Court TV has to say about this. I'm always curious about what they say. Oh, Judge Latham responded to the letter in a filing saying since Dinkins has a public defender, he shouldn't file any pro se document except for a motion seeking disqualification of appointed counsel. I didn't say all that. I just didn't understand why he was filing something not his attorney. He then states Dinkins' attorney should confer with him to, quote, determine whether any motion should be filed and set for hearing. Let me make sure that I did not miss a page. It says read letter here. So I clicked. Let me see. 1, 2, 3. Yeah, that's it. He didn't even sign it. Like, what are you doing, bruh? It's not even official if you don't sign it. Mac, ain't nobody trying to hear from you right now, buddy. You're going to have to wait a second. I will open the door in a minute. Can y'all hear him? Oh, bugaboo. Hang on a minute, y'all. Let me let this bugaboo out. Hold on. Sorry, y'all. We're full of professionalism over here at the ward. What was I gonna say? So it doesn't okay. So Cray says it doesn't sound like a full sentence. It sounds weird to me. It isn't a full sentence. What he has done is he's basically given like notes on law that he's citing. And case law is written in full sentences. It's not like that, you know. So hey Becky, you did miss the letter, babe. I just finished it. So and like the federal law that he's citing is a rule 37. A rule 37, let me just double check to make sure that what a federal rule 37 is. I'm pretty sure I know what it is, but let me just hold on. Okay. This is what it should have read. Rule 37, failure to make disclosures or to cooperate in discovery sanctions. What he's saying is that they held out stuff, that they withheld things. And this, hold on a minute. Let me make sure, because this is civil procedure. This is what he looked up, and that's not right. This is he wants criminal. Because I'm pretty sure Huh. I just he cited the one that he cited is civil, not criminal. Yeah, Federal Rules of Civil Procedure, because this is essentially what he wrote. And this is for civil. So I don't know what the hell he's trying to do. Apparently, basically, well, I mean, I kind of get it. Basically, he's saying that the state did not disclose um, evidence or stuff that they used to make, to do their exhibits, et cetera, et cetera. Well, like, I don't know what he's talking about, and quite frankly, that whole letter makes no sense because he's not citing he's citing the case law, but he's not citing the examples that pertain to his case. Okay. And I don't know what he's talking about that they manufactured. And the fact of the matter is there were certain pieces of evidence and exhibits that were stipulated that they had already agreed to, his attorney and the state. So I don't know what homeboy is talking about, to be quite honest. I don't know. And I just don't know. It is what it is. So that's what's going on with that. But I didn't intend on being on here super duper long. But I will stream the trial or the closing arguments for you guys on Friday. And then I told you guys I'm working on 2 videos. So one video is just to sort of give the backstory of the AJ Friend case, and or I think it's Freund, and the way they say it in when the attorneys say it on the in the courtroom is Frun, like friend. I don't know. It's weird how they say it. Hey, Crime Curious. So but yeah, I feel like I don't understand his letter or his purpose. Yeah, yeah, the judge's response is perfect because you don't like, what are you doing? Like, he's just saying to him basically, bruh, what are you doing? You have an attorney. This needs to come through your attorney. Let me just, I just want to check something because it's been a minute since I've looked. Let's see what old Sarah Boone's up to, shall we? Let's see if she's written another seething letter to the judge. Let's see. I'm curious if her attorney has contacted her in a timely manner. And by timely manner, I mean by real people time, not Sarah Boone time. Let's see. Because you know how impatient she is. And it's already Tuesday. I feel like we're gonna get I feel like, oh my God, here we go with the select all the bridges. I don't know why it picks this one for me. I never do good on this one. I think that's it. Oh, nope, failed. All right, hold on. All right, passed it the second time. All right, let's see. See if we got anything new. Hmm. Huh. Let's see what this is. I think these are just. All right, let me look at this. it's weird because he's still including him in like pretrial stuff. That's so weird. What's this? Because you know what they did? So right after they did the hearing, oh wait, hold on. Let me see what this is. Hold on. Let's see. Trial date. This case is set for a jury trial for the 3-week trial docket beginning Monday, December 11th, 2023. Pretrial scheduling conference. Counsel and parties, unless their presence is waived in writing prior thereto, shall attend a pretrial conference Tuesday, November 28th. Blah, blah, blah. Discovery. Blah, 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 blah. That's Wayne Wooten. And it was sent to, so weird. I don't know why it would be sent to her, but they reset her for they reset her as indigent. And let me see what these court minutes saying. Let's see. But there's been no letter. Yeah, I don't know why. Huh. They're still sending stuff to him, and I don't even understand that at all. Whatever. But there's nothing else new other than that. Huh. So I guess they're not going to do anything until like maybe in October they're going to try to do that other hearing with the JAC, but let me see, what are we laughing at in the chat here? Hey Corey, good to see you. Oh, number 7. Oh my god, bless it. So yeah, that's kind of all that I really had to report tonight. I don't really have anything else, just that, and just that I'm doing. I'm gonna do a video for AJ Friend so we can like catch up on the backstory of his case, because they're coming for the CP. They're coming for the 2 CPS workers, which is actually kind of surprising because, yeah, it's just kind of surprising, but because it doesn't really appear like in this case. Now, listen, I've got to do some more digging, but just from the opening statements, it doesn't appear like this family had the level of CPS involvement that like Gabriel Fernandez's family, did. So, but they're coming for the CPS caseworkers, and mainly the reason I wanted to talk about it is because I think that anytime a child suffers at the hands of their parents over a prolonged period of time where CPS has been involved at least a couple of times and they fall through the cracks, I think it's important to tell their story. But I also continue to want to bring these cases to the forefront because at the end of the day, CPS is a very overworked, understaffed agency in our country. And I still see on YouTube, and YouTube's not the only place. I don't see it as much on TikTok or anything, but I do see it a little bit on Facebook, where people are using CPS as a weapon in their war against another person. And I just want to keep reminding people that when that kind of stuff occurs, every time that happens, you run the risk of a child who truly does need the intervention and attention of CPS not getting it. So, That's my little soapbox, but I think it's an important soapbox to be on. You know, CPS, we do need, it needs a complete overhaul. It really does. And I feel like until we get there, I think as a true crime content creator, for me personally, I feel it's important to point these cases out so that we can continue, maybe at some point, covering these cases, all of us put our brains together and maybe we can come up with some type of viable solution for an overhaul of CPS, some way to make it work for these kids. Because we got to protect these little ones. Oh my. Hi, me again. Wow, that's messed up. I can't highlight that because but yeah, dang, law nerd animal. That animal, Amber, that's messed up. See, it's just, we just and they're only on day 2 of this case or of this trial. And I'm not gonna lie, there's some problems in this trial already, but we'll get to that. But I don't know if it's true, if the accusations are accurate against these 2 social workers, that they were incompetent and um they turned their backs on a child. But I just I just think it's an important case to cover. So anyway, and it's also a bench trial, no jury. So, but anyway, you guys, that's really all I had for you guys tonight. So with that, I'm gonna let y'all go. But thank you all for being here. It was good to see everybody. I'll be back tomorrow night. I want to go through a little bit more with Dinkins, a little bit more of his backstory, like his other charges and stuff like that, and then the situation with Andrea, because I want to verify that it is her, that this information is indeed accurate. So, in order for me to do that, I got to go back and watch um, some things so I can make sure we have the right person. But anyway, that's all I wanted to say for tonight. Thank you guys so much for being here. Have a great rest of your Monday night, and I will see you around these streets and then over here tomorrow night. All right. Bye.